Let us start with 360-degree analysis and recap of Course 2, Contract 1, Law of Contract of first semester KSLU 3LB program. We'll do quick recap, and we'll do very quick recap. I'm going to explain it very fast. I will explain in both Kannada and English. Too fast explain like an express train. So don't miss any points, okay? You don't have time, you need to study for exam, so I'm going to explain it very fast. I'm going to reveal all the important questions. We've already provided all these important questions to all of our IQCourt Law Academy students along with the answers. Now I'm going to reveal it to all of you so that all of you will get good marks. All of you will clear the exam. All of you should get the good marks and become a university topper, become college toppers. Let us reveal first question, first important question of Contract 1, Law of Contract of KSLU 3LB program, first semester. See, we have studied more than 30 question paper to prepare this important questions and also to provide important questions in our IQCourt premium high quality study materials. Even if you take 10 to 14 questions in a question paper, we have literally studied more than 500 questions per subject, we have studied more than 500 question paper. ಈ 30 question paper ಅನಲೈಸ್ ಮಾಡಿ ಒಂದೊಂದು question paper 14 question ಅಂದ್ರೆ more than 500 questions ನಾವು ಸ್ಟಡಿ ಮಾಡಿ ಇದನ್ನ ಪ್ರಿಪೇರ್ ಮಾಡಿದ್ವಿ. That is the scientific, real proven practical way we are telling the students that these are all important questions. Blind agi we are ಏನೇನು ಹೇಳ್ತಿಲ್ಲ, blind agi ನಾನು I'm not a god, I'm not a god to tell you that this question ಬಂದ್ಬಿಡುತ್ತೆ ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ಇದೇ ಬಂದ್ಬಿಡುತ್ತೆ ಆ ತರ ಎಲ್ಲ. It's not a thing. If you are telling, you should not believe that. If someone is telling I'm god, I'm going to tell you these questions will come in the exam, don't trust them. Ask for the proof, ask for the proof. We are revealing the proof. We IQCourt Law Academy will always provide questions, materials based on the proof, the scientific way, with the proof, with a clear-cut research on core concept of the law subject. That is the beauty of IQCourt Law Academy. We are studying more than 500 questions. That is the hard work and quality of the materials IQCourt Law Academy is providing to KSLU students. See this question, we revise the questions and notes for every 6 months, for every 6. You can see that this is the live, 2026, just 6 months back, this question came. This is how, based on the syllabus, we have segregated the questions. They are studying more than 500 questions. We have segregated the question based on the unit. Accordingly, we are included all the points, important concepts. Accordingly, we are providing the important questions to all our students. See, examiner may ask the question in different way. He may shoot the question in different angle, 90 degree, 60 degree, 50 degree, in different way, tricky way. We will use a different words to confuse the students. He will literally confuse students. See, I've seen most of the IT students, most of the working people, they are unable to clear this subject. This is a very easy subject. I'm telling you, it's a very easy subject. Even primary school student can write and clear the exam, but the IT people who are working professional, they are unable to clear the subject because they don't know the basic concept, basic important things they need to write in the exam. That is the problem. That is the only problem. I've seen students studying all those important concepts, points, sections just in one day and wrote the exam and cleared the exam, got highest score also. This is one of the easy subject, but without knowing the concept, without understanding the question, if you are going to study, it will be difficult for you. I've seen people are in 4th sem, finally they are telling, sir, one subject that is contract 1. Contract 2 is easy, sir. Contract 1 is difficult, sir. I don't know, but this is one of the my favorite subject and very easy subject because they are not students are not getting proper guidance, proper study materials. See, in this, to clear the exam KSLU, you should know which are the things you should not study. ಏನು ಓದಬೇಕು ಅನ್ನೋದಕ್ಕಿಂತ KSLU ನಲ್ಲಿ ಯಾವುದನ್ನ ಓದಬಾರ್ದು ಅನ್ನೋದು ತಿಳ್ಕೊಂಡ್ರೆ ನೀವು ಆರಾಮಾಗಿ ಒಳ್ಳೆ ಸ್ಕೋರ್ ಮಾಡ್ತೀರಾ. ದಟ್ ಇಸ್ ದ ಬ್ಯೂಟಿ ಆಫ್ KSLU. KSLU ಎಕ್ಸಾಮ್ ತುಂಬಾ ಓದೋದಕ್ಕೆ ಹೋದ್ರೆ ನೀವು ಈ ಎಷ್ಟೋ ಎಕ್ಸಾಮ್ ಬರೆಯೋದಕ್ಕೂ ಪಾಸ್ ಆಗಲ್ಲ. ಸೊ ನಿಮ್ಗೆ ಯಾವ್ದು ಓದಬಾರ್ದು ಅಂತ ಗೊತ್ತಿರ್ಬೇಕು. ಸುಮ್ಮನೆ ರ್ಯಾಂಡಮ್ ಆಗಿ ಟೆಲಿಗ್ರಾಮ್, ವಾಟ್ಸ್ಆಪ್, ಫ್ರೆಂಡ್ ಕೊಟ್ಟರು ಅಂತ ಕ್ವಶನ್ಸ್. lecture on 40 questions, so your professor will give 40 questions, your friend will give 40 questions important, then some people will post 40 questions handwriting notes. That this not 100 questions, important questions. If you're going to study this, when will you study other subjects? This is the problems. This is the main reason students are not able to clear the KSLU exams. They are not able to get the correct, perfect study materials. That is where they are lacking, that is where they are lacking. We are providing you the all important questions along with the answers, and we are removing which are all not important. Our IQCourt study materials are exam oriented, we are not going to tell you some stories, all those things which are all important for exam. Only that much only we are covered. We are openly telling all our materials are exam oriented, because all students are asking, sir, you give me exam questions. I have studied a lot. I have attended all the classes. Still, I am not able to clear the exam. I have attended all the classes. I have attended all long notes, books, everything I studied, sir. I am not able to clear the exam. So all students are asking, so instead of conducting the complete all classes, just explain important questions and on the answer to them. How to write the exam, which are the points need to be written in the exam for each questions, which are the sections, which are the case laws are important, which are the important questions they need to concentrate. Only those things students are demanding, students are literally demanding. Nobody is giving the important questions properly, and nobody is properly giving the answers also. So students are literally struggling, So we are providing only exam questions and answers. And also we are making the complete video on all the questions, all important concepts. See, if you study all important questions, you'll understand the complete core of the subject. You can further elaborate on your own. In the study material, we have covered everything, all the points. We have just given less priority in the less explanation for points which are not important, and elaborated which are for the points which are highly important, likely to come in the exam. That is a way we have designed IQCourt Law Academy study materials. Nobody will give you the answers, nobody will give you the answer, perfect answer. You write this answer, write this synopsis, you write this is the introduction, this is the conclusion. No, you will not find like that anywhere else. Even if you find also, it will be like Bible to 500, 400, 300 pages. So instead of studying that, you can go and study some books itself, direct, full of technical words. You will not understand immediately. So our study materials are like full of easy concepts, simplified, very easy for you to understand. Say some of the students are asking, sir, your notes is very easy, sir. I want full of technical words, some difficult way, some full standard way I want to study. In those cases, you should go and buy the book and study. If I'm going to explain those, if I'm going to print the same thing in the IQCourt study material, then what is the use of providing the materials by IQCourt? You can just go and study, right? If I'm providing notes, it should be very much simplified. Students should be able to understand just by reading the material. They should be able to understand each and every concept with full of examples in a simplified words, which are all important questions, sections. That is the main intention of IQCourt Law Academy. I'm going to reveal the questions. Tomorrow you will go and write the exam. You will get the questions from these importance question list. This is our study materials. We are not seeing these study materials. We have provided only 32 pages. In this we have covered all those important questions. We have provided the answers as well for all those questions for our IQCourt Law Academy students. Now we are revealing all those individual questions which they may ask in different angles. We have covered everything. The question examiner may ask the question in different angles, so you should be able to answer. You should be able to understand. That is the reason we are displaying all the way they may ask, different way they may ask. All those things we are displaying on the screen right now. Many students failed contract 1 exam. They are clearing contract 2, 4th sem, 5th sem. They are struggling. They are struggling to clear this exam. One of the easy subject in law. Let us reveal first question, first important question, most important question. I'm going to reveal 90% important and 50% important and 30% important questions. For 90% important, don't skip this question. Okay, study this well and don't skip any question. Okay, you have to study all the question. I'm just telling you the priority in which you should study. For 90% question, you should be ready to write 4 to 5 pages in the exam. So that much you should study. For 50%, you can study as per your wish. For 30%, you can study 1 or 2 pages. Don't skip any questions. Examiner may ask any questions. We are not got to tell he will ask this question only tomorrow. That I can't tell. I can give you the priority wise. I can tell you this is 90% important. You will ask this question. This is a very, very important. This is a core important question. Like that I can explain. Okay. Without wasting much time, let us start. This question is very important. State the exception to the rules that an agreement without consideration is void. ಪ್ರತಿಫಲವಿಲ್ಲದ ಒಪ್ಪಂದವು ಶೂನ್ಯ ಎಂಬ ನಿಯಮಕ್ಕಿರುವ ಅಪವಾದವನ್ನು ತಿಳಿಸಿ. Explain the consideration with reference to decided cases. ಪ್ರತಿಫಲವನ್ನು ನಿರ್ಧರಿಸಲ್ಪಟ್ಟ ಪ್ರಕರಣದೊಂದಿಗೆ ವಿವರಿಸಿ. These are all about consideration. Consideration means money or anything is in return for something. Without consideration, agreement is void. Agreement is void. People are not able to clear the exam because they are unable to understand the basic concept. Agreement is different. Contract is different. Both are different. Simply if you're studying, you will not understand immediately. Agreement means just a normal agreement. Contract means legally enforceable agreement. You can go to court and ask, sir, he has signed, he is not paying the money, like that. Legally valid agreements are contracts. That is the reason all contracts are agreement. Not all agreements are contract, because we don't know whether it is legally valid or not. That is the reason all agreement can't be contract, but all contracts will be agreement. Very simple, very easy concept. You should know this. Pratipala means some ನೀವೇನಾದ್ರೂ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ನಿಮ್ಗೆ ಅಮೌಂಟ್ ಕೊಟ್ಟಿರ್ಬೇಕಲ್ವಾ. ಸುಮ್ನೆ ನೀವು ಮನೆಯಲ್ಲ ಬೇರೆಯವ್ರಿಗೆ ಬರ್ಕೊಟ್ಬಿಟ್ರಿ ಅಂದ್ರೆ ಏನೋ ಮಿಸ್ಟೇಕ್ ಇದೆ ತಾನೆ. ಸೊ ಆತರ ಏನು ವಿತೌಟ್ ಕನ್ಸಿಡರೇಷನ್, ವಿತೌಟ್ ಮನಿ, ಇಫ್ ಯು ಆರ್ ಪೇಯಿಂಗ್, ಪ್ರತಿಫಲ ಮೀನ್ಸ್ ಸಮಥಿಂಗ್ ರಿಟರ್ನ್. ನೀವೇನಾದ್ರೂ ಕೊಡ್ತಿದ್ದೀರಾ ಅಂದ್ರೆ ಅದು ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಏನೋ ಸೈನ್ ಮಾಡಿದ್ರೆ ಅದು ಇನ್ ವ್ಯಾಲಿಡ್ ಅಲ್ಲ, ವಾಯ್ಡ್ ಅಂತ ಹೇಳುತ್ತೆ. ಬಟ್ ಇಟ್ ಈಸ್ ಆಲ್ಸೋ valid in some of the circumstances, which are those they are asking to explain in this question. Exceptions, state the exceptions to the rule that an agreement without consideration is void. Very, very important question. That 95% chances are there. You'll get it in the exam. Second important question. See, I will tell you in the first unit, all these three questions are 95% important. You can't skip. You may ask any question. You may ask any question. You may shoot it in different wordings. See, you may ask like this also. You may ask different way. You will ask the question. But all three questions are very, very important. First unit, that is related to consideration and exception. Both are very, very important. And proposal, offer, acceptance. This is very, very important. 95%. Define proposal. Explain the circumstances under which it lapses. ಪ್ರಸ್ತಾವನೆಯನ್ನು ವ್ಯಾಖ್ಯಾನಿಸಿ. ಅದು ಯಾವಾಗ ರದ್ದಾಗುತ್ತೆ ಪ್ರಸ್ತಾವನೆ? You are giving the offer to someone. That is proposal. Okay. Define acceptance and what are the rules of acceptance. What is acceptance? Explain the essentials of valid acceptance. This is a very, very important question. Definitely will ask. Okay, what is acceptance? Define offer. Acceptance. Explain both are different. You have to offer, the person has to accept. Explain the rules regarding their revocation, means cancelling the offer or acceptance, when they can cancel. Explain the acceptance and state the rules as to revocation and acceptance. ಸ್ವೀಕೃತಿ ಮೀನ್ಸ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ವಿವರಿಸಿ. ಸ್ವೀಕೃತಿಯನ್ನು ಹಿಂತೆಗೆದುಕೊಳ್ಳುವ ನಿಯಮಗಳನ್ನು ವಿವರಿಸಿ. ನೀವು ಯಾರಿಗೋ ಆಫರ್ ಕೊಟ್ಟಿದ್ದೀರಿ, ಅದನ್ನು ಯಾವಾಗ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಕೋಬಹುದು ಅಂತ ಕ್ವಶನ್ಸ್ ಕೇಳಿದ್ದಾರೆ. ಅಂಶಗಳನ್ನ ಕೇಳಿದ್ದಾರೆ. ಇಂದು ತಗೋಬಹುದಾ? ಪ್ರಸ್ತಾವನೆ, ಸ್ವೀಕೃತಿ ವಿವರಿಸಿ. ಅವುಗಳನ್ನು ಹಿಂಪಡೆಯಬಹುದಾ? ಈ ತರ ವಿಲ್ ಆಸ್ಕ್ ಡಿಫರೆಂಟ್ ವೇ. This question asked in 2025. An agreement is enforceable by law is an agreement. Very simple. This is word is very simple, very easy. Very. See, there's nothing else. Just you have to write the essentials of agreement. He is asking a different way. It is very simple. ಕಾನೂನನ್ವಯ ಜಾರಿಗೊಳಿಸಬಹುದಾದ ಒಪ್ಪಂದವು ಕರಾರಾಗಿರುತ್ತದೆ. This came in 2025. So now this is already July 25 already question paper came. Now this is 2026. So you may ask this question. All contracts are agreements, but all agreements are not necessarily contract. See, very easy question. Don't get confused. This is the first question in our study material. Very, very basic. Easy question, very, very basic, easy question. This is the first question. Define all contracts are agreement, but all agreements are not necessarily contract. I already explained, in daily human business, every transaction is built on an agreement governed by the Indian Contract Act 1872 to strictly protect the mutual legal rights. See, these are all tricks only for your understanding. Don't write it in the exam. These are all tricks provided to IQCourt Law Academy students. This is the section important. You have to write it in the exam. 2 class H section is definition of contract. An agreement enforceable by law is a contract. The simple formula is you have to write this. Contract equal to agreement for enforceability. ಕಾಂಟ್ರಾಕ್ಟ್ ಅಂದ್ರೆ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ತಾರಲ್ಲ, ಅದು ಜೊತೆಗೆ ಕಾನೂನು ಪ್ರಕಾರ ಅದು ಸರಿಯಾಗಿರ್ಬೇಕು. ಇವೆರಡನ್ನು ಕಂಬೈನ್ ಮಾಡಿದ್ರೆ ಅದೇ ಅಗ್ರಿಮೆಂಟ್, ಅದೇ ಕಾಂಟ್ರಾಕ್ಟ್. ಸೊ ಅವರೆಲ್ಲ ಡೆಫಿನೇಷನ್ಸ್ ಇದೆ, ಡೆಫಿನೇಷನ್ಸ್ ಬರಬೇಕು. ವಾಟ್ ಇಸ್ ಅಗ್ರಿಮೆಂಟ್? ಅಗ್ರಿಮೆಂಟ್ ಮೀನ್ಸ್ 2 class E. 2 class E agreement section. Every promise and every set of promises forming the consideration for each and other is an agreement. Formula is agreement equal to offer plus acceptance. You will not get this kind of explanation simplified way anywhere else. This is the beauty of IQCourt Law Academy study materials. All contracts are agreement, but all agreements not necessarily contracts. So this is the explanation. You have to write basic thing I already explained, and also you have to see, this is very, very important. You have to study this, very, very important, 200% important. You have to write this for all the questions of first unit. Basic, at least basic things you should write. Case laws are there, section 2 class A. Case laws are there, section 13, 14. Everything is there. What are the essentials you have to write? Okay, very basic thing, very common sense, very basic common thing. This subject is very basic things. Offer, that I explained, very important question. 95% important question. Offer, acceptance, proposal. Offer or proposal, both are same. Acceptance. See, define offer. See, explain essential rules for valid acceptance and illustrate. Example, see, revocation, everything we have covered. See, this is the study material. See, we have covered everything in the single question. That is the beauty of IQCourt study material, See, we combined everything in the single question. You may ask, you just have to study. Everything is ready in IQCourt study, just have to study. Everything we have covered revocation, circumstantial collapse, can they be revoked? Distinguish it from the invitation to offer. Everything we have covered. That is the way we explained. Every contract starts with a legal journey when one person makes a proposal or offer and the other person gives a clean, unqualified acceptance. In this answer, you will be learning offer and invitation to offer. Both are different. ಪ್ರಸ್ತಾವನೆಗೆ ಆಹ್ವಾನ ಎರಡು ಕೂಡ ಡಿಫ್ರೆಂಟ್. ಪ್ರಸ್ತಾವನೆ ನೀವೆಲ್ಲ ಪ್ರಸ್ತಾವನೆ ಮಾಡ್ತಿದ್ದೀರಾ ಅಂತ. ಪ್ರಸ್ತಾವನೆಗೆ ಆಹ್ವಾನ ಅಂದ್ರೆ ನೀವು ಬಾ ನೋಡೋಣ ಅಂತ. ನೀವು ಯಾವ್ದಾರ ಶೋರೂಮ್ ಹೋಗಿ ಈ ಬಟ್ಟೆ ಬೇಕು ಅಂತ ನೀವು ಕೇಳ್ತೀರಾ, ಅವನು ಕೊಡೋದಕ್ಕಾರ ಕೊಡೋದು, ಬಿಡೋದಕ್ಕಾರ ಬಿಡ್ಬೋದು. ಅವನೇ ನೀನ್ ಬಂದು ತಗೋ ಅಂತ ಕೊಡ್ತಿಲ್ಲ. ಓಕೆ, ದಟ್ ಇಸ್ ಅ ಡಿಫ್ರೆಂಟ್ ಥಿಂಗ್. ಬಂದು ನೋಡು ಆಮೇಲೆ ತಗೊಂಡು ಬಾ ನೋಡ್ರಿ ಕೌಂಟರ್ಗೆ, ಆಮೇಲೆ ಅವನು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಕ್ಕೆ ಬೇಡ, ಅವ್ನು ಡಿಸೈಡ್ ಮಾಡ್ತಾನೆ. ಅದನ್ನ ಪ್ರಸ್ತಾವನೆಗೆ ಆಹ್ವಾನ ಅಂತ ಕರೀತಾರೆ. ಇನ್ವಿಟೇಷನ್ ಟು ಆಫರ್. ಎರಡು ಬೋತ್ ಆರ್ ಡಿಫ್ರೆಂಟ್. ದಟ್ ಇಸ್ ವಾಟ್ ಯು ನೀಡ್ ಟು ರೈಟ್ ಅಷ್ಟೇ. ಪ್ರಸ್ತಾವನೆ ಅಂದ್ರೆ ನೀವು ಆಲ್ರೆಡಿ ಕೊಡೋಕೆ ರೆಡಿ ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಾ, ತಗೊಂಡು ಕೊಡ್ತಿದಾರ. ಇದು ಬಾ ನೋಡು ಆಮೇಲೆ ನಾನು ಡಿಸೈಡ್ ಮಾಡ್ತೀನಿ ಕೊಡ್ಬೇಕೋ ಬೇಡ ಅಂತ. ಎವ್ರಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಓಕೆ ಮುಗಿತು. ಓಕೆ, ಪ್ರಪೋಸಲ್ ಆರ್ ಆಫರ್ ಕ್ಲಾಸ್ ಸೆಕ್ಷನ್ 2 class A, acceptance is 2 class B. Essentially you have to write essentials should be absolute and unqualified. And this is the case law. You have to write must be accepted by the A party is offering, other person should accept it. If one person you are telling 100 rupees means if 100 rupees you have to give now only means you should say yes, then that will be a proper proposal. Then if that person is B is accepting means that is he has accepted the proposal. If he is telling no make it 90 rupees means it is a counter proposal, means counter offer. It is not at all acceptance. Must be accepted by the other person to whom it is made. So case laws are there. You have to write the case laws. And the silence can't imply acceptance. An offerer can't bully you by stating if you stay quiet for 3 days, I will assume you accepted. If someone is telling you if you are not communicating anything means it is not automatic acceptance. Acceptance should be clearly communicated. Acceptance must exceed the offer. Everything you have to write regarding the rule, regarding the revocation. Can it be revoked? Everything you have to write. Circumstances under which a proposal lapses. When ಯಾವಾಗ ಲ್ಯಾಪ್ಸ್ ಆಗುತ್ತೆ, ಅವನು ಬೇಡ ಅಂತ ಕಂಪ್ನಿ ನೋಟಿಸ್ ಕೊಟ್ಟಾಗ, ಲ್ಯಾಪ್ಸ್ ಆದಾಗ, ಫೇಲ್ಯೂರ್ ಟು ಫಿಲ್ ದ ಕಂಡೀಷನ್ ಏನೋ ಕೊಟ್ಟು ಹಾಕಿತ್ತು ಅದನ್ನ ಫುಲ್ಫಿಲ್ ಮಾಡದೇ ಇದ್ದಾಗ, ಡೆತ್ ಆದಾಗ, ಕೌಂಟರ್ ಆಫರ್ ಮಾಡಿದಾಗ, ದಿಸ್ ಪರ್ಸನ್ ಟೆಲ್ಲಿಂಗ್ 100 rupees, ದಿಸ್ ಪರ್ಸನ್ ಇಸ್ ಟೆಲ್ಲಿಂಗ್ 90 rupees, then offer is cancelled. So distinguish, we have to write distinguish everything you have to write. Let us go to that is we still going. We need to go to next question. Next question is this one. This is very very important. They will ask a different way related to consideration. Third important question, define consideration, explain the valid essentials. Okay, this is very very important. Bare agreement without consideration is dead, void. That agreement itself void. But there are some exceptions that you will study now. See, essentials of a legal valid. Essentials you have to write for all the question. Definition section you have to write. This is also you can write. As if you don't know the section range, you can just write range. Consideration need not be adequate. See, consideration no need to be adequate. Like it should be 1,000 rupees, then nothing. Even 1 rupee also it is valid. Okay, all these things you have to write. Exceptions you have to write. Very very. They will ask definitely like this only. He will ask. Section 25. So many sections are there. You don't study everything. You just study which are all important. Natural love and affection. See, when without consideration also contract will be valid. I mean that these are in these circumstances. A written or government registered agreement made between close blood or marriage relatives out of genuine natural love is valid without consideration. These are all things you have to write. Past voluntary services. A promise compensate to a kind person who voluntarily did helpful past service for a promiser, like searching or returning a lost. ನಿಮ್ಗೆ ಯಾರೋ ಹೋಗ್ತಿದ್ದೀರಾ, ನೀವು ಇಲ್ಲಿ ಹೋಗ್ಬೇಕಾದ್ರೆ ಏನೋ ಐಟಮ್ ಸಿಕ್ಬಿಡ್ತು, ಅದಕ್ಕೋಸ್ಕರ ನೀವು ಅವ್ನು ತಗೊಂಡೋಗಿ ಕೊಡ್ತೀರಾ, ಅದಕ್ಕೆ ಅವ್ನು ನಿಮ್ಗೆ ಮನೆ ಬರ್ಕೊಟ್ಬಿಡ್ತಾನೆ. ಸೊ ವ್ಯಾಲಿಡ್ ಆಗುತ್ತೆ. ನೀವು ಏನೋ ಹೆಲ್ಪ್ ಮಾಡಿದಿರಾ ಅಂತ ತಾನೇ ಅವ್ನು ನಿಮ್ಗೆ ಹೆಲ್ಪ್ ಮಾಡ್ತಿರೋದು. ಸೊ ಅದು ವ್ಯಾಲಿಡ್ ಆಗ್ಬಿಡುತ್ತೆ. ಪ್ರಾಮಿಸ್ ಟು ಪೇ ಎ ಟೈಮ್ ಬಾರ್ ಡೆಟ್. ಟೈಮ್ ಮುಗಿದೋಗ್ಬಿಟ್ಟಿದೆ, 3 ವರ್ಷಗಳ ಟೈಮ್ ಪೇ ಮಾಡಬೇಕು, ಟೈಮ್ ಬಾರ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ, ಆದ್ರೂ ಪೇ ಮಾಡ್ತೀನಿ ಅಂತಂದ್ರೆ ಅವಾಗ ಅದು ಎಕ್ಸೆಪ್ಷನ್ ಇರುತ್ತೆ. ಸೊ ದಟ್ ಇಸ್ ಆಲ್ಸೋ ವ್ಯಾಲಿಡ್ ಕಾಂಟ್ರಾಕ್ಟ್. ಸೊ ದೀಸ್ ಆರ್ ಆಲ್ ಥಿಂಗ್ಸ್ ಯು ಹ್ಯಾವ್ ಟು ರೈಟ್. ಸೊ ದಿಸ್ ಸೇಮ್ ಕ್ವೆಶ್ಚನ್ ವಿ ಹ್ಯಾವ್ explained in the study material. Exact same question, because students should not skip this. State the exception to the rule that an agreement without consideration is void. Explain the statement with exception. See, same question. No, we were just you have to write extra, so 2-3 points only. We explained separate question. We made it separate question in our study material so that you should score good marks. See, exceptions only we wrote separately. See, these many 8 points we wrote. No, 8 points. Essentials you write. So we made it separate question because very very important. This question is very very important. That is the reason. In these circumstances, without money, without consideration, agreement will be valid. Let us go to second unit. Free consent, fraud. Free consent should be ಇರಬೇಕು ನಿಮಗೆ. ಸುಮ್ಮನೆ ಯಾರ ಹತ್ರ ದುಡ್ಡು ಇಸ್ಕೋಬಹುದು, ಇನ್ನೊಂದು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಸ್ಕೊಬಿಟ್ಟು ಚಾಕು ಹಿಡ್ಕೊಬಿಟ್ಟು ಸೈನ್ ಮಾಡು ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ವ್ಯಾಲಿಡ್ ಆಗಲ್ಲ. ಕಾಂಟ್ರಾಕ್ಟ್ should always have free consent. If you are signing something because he's threatening you to sign the agreement, otherwise he will kill, then it is not a valid contract. There should be a free consent. Fraud, this question will come. Define the fraud, distinguished from the misrepresentation. ತಪ್ಪು ನಿರೂಪಣೆ, ಮಿಸ್ ಆಗಿ ಇದೇ ಹೇಳೋಕೆ ಅದೇ ಹೇಳ್ಬಿಟ್ಟೆ ಆ ಮನೆ ಹೇಳ್ಬಿಟ್ಟೆ ಅಂದ್ರೆ ಅದು ತಪ್ಪು ನಿರೂಪಣೆ ಅಷ್ಟೇ. ಫ್ರಾಡ್ ಅಂದ್ರೆ ಬೇರೆ, ತಪ್ಪು ನಿರೂಪಣೆ ಅಂದ್ರೆ ಬೇರೆ. ಬೋತ್ ಆರ್ ಡಿಫರೆಂಟ್. This question also important. Top question, 90% important question. Then this is also very very important. This you will study in second, third, fourth, fifth, all SFEM you will study this question. Very very important, very basic question, very very important. Explain the provisions related to the capacity to contract. ಕರಾರನ ಅರ್ಹತೆಗೆ ಸಂಬಂಧಿಸಿದ ಉಪಬಂಧವನ್ನು ವಿವರಿಸಿ. Tomorrow you are going to write the exam. You will come and tell me you got the same, or any of the, only these questions will come in your exam. That is for sure. 100% sure you will get the same questions. You will not get any other questions. Tomorrow you will go and write the exam. You will come and tell me whether you got the same question or not. Definitely you will come and tell me you got the same question, sir. You will come and tell, I will tell yes, I know it. Okay, that is the way we have done the research. See, explain the provisions relating to capacity to contract. ಕರಾರಿನ ಅರ್ಹತೆಗೆ ಸಂಬಂಧಪಟ್ಟ ಉಪಬಂಧವನ್ನು ವಿವರಿಸಿ. Discuss with the help of decided cases contractual capacity of minors in India. ಭಾರತದಲ್ಲಿ ಅಪ್ರಾಪ್ತ ವಯಸ್ಕರ ಒಡಂಬಡಿಕಾ ಸಾಮರ್ಥ್ಯವನ್ನು. See, minor is there, right, below 18. Whether he can enter into the contract. Regarding that, you have to write the explanation. That's it. Very simple. Very, very simple. Whether it is valid, no, he is not responsible. Very simple. That's it. Nothing else. Then second one is legality of object and void contract. An agreement in restraint of the trade is void. See, ಏನೋ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ತೀರಾ ನೀನು, ಇದೇ ನೀನು ಊರ್ ಬಿಟ್ಟು ಹೋಗ್ಬಿಡ್ಬೇಕು, ನೀನು ಮನೆನೆಲ್ಲ ಎಲ್ಲೂ ವ್ಯಾಪಾರನೇ ಮಾಡಬಾರ್ದು, ಆ ತರ ಏನಾದ್ರು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಅದು ಇನ್ವ್ಯಾಲಿಡ್. ವ್ಯಾಪಾರವನ್ನು ನಿರ್ಬಂಧಿಸುವ ಒಪ್ಪಂದವು ಶೂನ್ಯ. ಈ ನಿಯಮಕ್ಕೆ ಅಪವಾದಗಳನ್ನು ವಿವರಿಸಿ. ಇದೆ ಅಷ್ಟೇ. ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಕ್ವಶನ್. ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. This is third important question I'm telling you. Okay, then this is the fourth important question. So this came only 3 times. Actually I'm telling you, they will give this question. This is very very important question. 2025 it came, right? If examiner wants to make the paper a little bit tough, means definitely will give this question. That is the beauty of IQCourt. KSLU. That is the beauty of KSLU University, not IQCourt Law Academy. ಘಟನಾನ್ವಿತ ಕರಾರು means contingent contract. If something happens, then only that contract will come into force. That is what contingent contract. Let us go to answers. Okay, this is Kannada medium notes. Okay, this is Kannada medium. This is English medium. Okay, we'll go to second unit. See, in first unit we are given only 3 questions plus 1 extra question. This is we are explaining about minor, related to minor, and also explain the provisions related to the capacity entered into this contract. This related to minor we explained. See, who are competent to enter contract. Person incompetent to the contract. Who are those things you have to write? Legal effect of minor agreement. See, this case law very very important. If you are not writing this, you will give less mark. You have to write this question. Very famous case law, landmark case law, top case law, very very important case law, amazing case law. Okay, you have to write this case law. Okay, this questions we have covered everything in the study material. No need to worry at all. See, consent, free consent, everything we have covered. Sammati, you know, sammati means yes, saying yes. That's it. It should be free of consent. That's it. Very easy question. You can write very very easy. You know. See, an agreement to become a binding contract. Section 10. Very very important. Section 10 you have to write everywhere. All the questions you should write. Section 10 very very important. Mandates that both the consideration and objects must be completely lawful and clean. Object means, if you are telling you give me drugs, I will give you house. Like that, if you are making the contract, means it is not valid. So it should be lawfully valid. Objects should be perfect. Most importantly, however, the agreement that blocks someone's daily business are treated as opposite to public policy. So that contract will be invalid. Very simple. Then we'll go to second, fourth. Contingent contract. While normal agreement requires immediate certainty, real life business is full of unexpected twists. So law recognizes contingent contract based on future uncertain events like insurance. Okay, if something happens, then only that contract will come into picture. That is what we call contingent contract. However, placing a blind money bets without any genuine risk is called wagering contract. Jujata Uppanda, which law strictly throws away and as void to protect the society from gambling. What is a contingent contract? Definition section. This is now 50% important question. He will not ask, but he may ask, but you just study. Usually they will not ask this question. Next, third unit, this is very very important. Modes of discharge of contract. ಯಾವ ತರ ಕಾಂಟ್ರಾಕ್ಟ್ ನ ಮಾಡ್ಕೋಬಹುದು, ಡಿಫರೆಂಟ್ ವೇ ನಲ್ಲಿ ಮಾಡ್ಕೋಬಹುದು, ಅದೆಲ್ಲ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಬೇಕು. ಇದು ಈ ತರ ಲಾಸ್ಟ್ ಕ್ವಶನ್ ಲೈಕ್ ದಿಸ್ ಆಲ್ಸೋ. ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಇಸ್ ನಾಟ್ ದ ಓನ್ಲಿ ಮೋಡ್ ಇನ್ ವಿಚ್ ಎ ಕಾಂಟ್ರಾಕ್ಟ್ ಇಸ್ ಡಿಸ್ಚಾರ್ಜ್. Decide with the decided case laws. More VB case law is very very important. Bol per case law is very very important. Those two case laws you can write for most of the questions. Explain the different modes of discharge of contract. ಒಡಂಬಡಿಕೆ ವಿಸರ್ಜನೆ ವಿವಿಧ ವಿಧಾನಗಳನ್ನು ವಿವರಿಸಿ. Explain the different modes of discharge of contract. ಕರಾರು ವಿಸರ್ಜನೆ ವಿವಿಧ ವಿಧಾನಗಳನ್ನು ವಿವರಿಸಿ. Explain the different modes of see. So many times he asked, same question. This is third unit, very very important. That question is very very. Then we'll go to second question. Breach of contract. State the effect of anticipatory breach of contract. ಕರಾರು ಉಲ್ಲಂಘನೆ ಎಂದರೇನು? ಒಡಂಬಡಿಕೆ ನಿರೀಕ್ಷಣಾ ಉಲ್ಲಂಘನೆಯ ಪರಿಣಾಮಗಳನ್ನು ಹೇಳಿರಿ. Define breach of contract. Discuss kinds of breach of contract. Breach of contract ಉಲ್ಲಂಘನೆ ಆಗೋದು ಅಷ್ಟೇ ಏನಿಲ್ಲ, ವೆರಿ ಸಿಂಪಲ್. ಬೇಸಿಕ್ ಕಾಮನ್ ಸೆನ್ಸ್, ವೆರಿ ಈಸಿ ಸಬ್ಜೆಕ್ಟ್. ಯು ಟು ಅಪ್ಲೈ ಯುವರ್ ಬೇಸಿಕ್ ಕಾಮನ್ ಸೆನ್ಸ್. ದಟ್ಸ್ ಇಟ್. ಯಾವಾಗ ಉಲ್ಲಂಘನೆ ಆಗುತ್ತೆ? It's a very easy question. Anticipatory breach of contract. State the effect of anticipatory breach of contract. This question also very important. Doctrine of frustration. Explain the doctrine of frustration with discussion. Nishpala tattva. Ashabanga tattva. Kannada medium, you will have to cry only. You will ask, you will use the Kannada medium ಅಳ್ತಾ ಇರಬೇಕು. ಏನೇನೋ ಕೇಳ್ತಾರೆ ಕ್ವಶನ್, ವರ್ಡ್ಸ್ ನೀವು ಕೇಳಿ ಹೇಳಿದಿರ ಲೈಫ್ ಅಲ್ಲಿ ಆತರದ್ದು. ಏನು ಆಶಾಭಂಗ ಅಂತೆ, ನಿಷ್ಫಲ ತತ್ವ ಅಂತೆ, ಏನ್ ಬರೀ ಎಕ್ಸಾಮ್ ಎಕ್ಸಾಮ್ ಬರೀ ಗೊತ್ತಿದ್ದಿಲ್ಲ. ಕನ್ನಡ ಪಂಡಾರ ಕಲಿಯಕ್ಕೆ ಗೊತ್ತಿದ್ರು ಗೊತ್ತಾಗಲ್ಲ, ಹಂಗಾಗ್ಬಿಡುತ್ತೆ ಎಕ್ಸಾಮ್. ಏನೇನು ಮನ್ಸಿಗೆ ಬಂದಂಗೆಲ್ಲ ವರ್ಡ್ಸ್ ಕೊಡ್ತಾರೆ. ನಿಷ್ಫಲ ತತ್ವ ಹಿಂಗೆಲ್ಲ ಕೇಳ್ತಾರೆ. ಸ್ಟೂಡೆಂಟ್ಸ್ ಆನ್ಸರ್ ಗೊತ್ತಿರುತ್ತೆ, ಬರೆಯಕ್ಕಾಗಲ್ಲ, ಆತರ ಎಲ್ಲ ಕೊಡ್ತಾರೆ. ಅದೇನಕ್ಕಾಗ ಮಾಡ್ತಾರೆ. ಕ್ರಿಟಿಕಲಿ ಎಕ್ಸಾಮಿನ್ ದ ಡಿಸ್ಚಾರ್ಜ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಬೈ impossibility of performance. This is very very important. You will ask question like this only. You will definitely ask like this. ನೆರವೇರಿಕೆಯ ಅಸಾಧ್ಯತೆಯಿಂದ ಕರಾರಿಂದ ಬಿಡುಗಡೆಯಾಗುವುದನ್ನು ವಿಮರ್ಶಿತವಾಗಿ ತಿಳಿಸಿ. If you want to make the question better, definitely you will ask like this only. See that very you should understand time and place of this is only one time it was asked in 2017. No, but if you want to make the question really tough, then you will ask. Otherwise, this only 50%, 30% important question. You decide. Okay, I will go to the fourth unit of third unit. Okay, third unit. This first, as per our case, IQCourt Law Academy, this question is top question we are given to our students. Okay, performance not the only mode in which a contract is discharged. Same question. Explain the law, time and place. Same question we have covered is here also. We have not left out anything because that is very important. Performance is not the only mode of discharge. This is a top question as per our IQCourt Law Academy study materials we are giving to our students. Topmost important. When two citizens sign the contract, they have a strict duty to fulfill their promise. Ending this duty is called contract. Ibru contract ಮಾಡ್ಕೊಂಡು end ಆಗಿ ಮಾಡ್ತಾರ, then discharge of contract. While completing the job through performance is the normal way out. Law provides many other valid paths to cancel the agreement without doing the work. Various modes by performance. When both parties finish the work, it is over. We are given something contract to deliver the car. He delivered over. Taking 2 cases is over. Contract is over. By agreement, mutually cancelling the old contract. That's it. By making new contract. In that case also, these are all the different various way we have to write. Then decide case laws you have to write. This is very very important. You just remember Taylor. Cloth Taylor is there, right? Cloth Taylor. That one you remember. Andre Viruddha Box Handle. This is very important case law. This is also very important case law. All these 3 case laws are very important. Whether you study or not, that is your wish. This is not that important. Okay, you write it. So look, go to next question. Doctrine of frustration. Impossibility of performance. ನೀವೇನೇ ಹೇಳ್ತೀರಾ ಏನಂತ, ಮಗ ಓಡೋಗು 500 ಕಿಲೋಮೀಟರ್ ಓಡೋಗು, ನಿಂಗೆ 1 ಕೋಟಿ 10 ಕೋಟಿ ಕೊಡ್ತೀನಿ ಅಂತ ಓಡಕ್ಕಾಗುತ್ತಾ? That is what question. With different cases, sudden natural disaster, government bans can make the work completely impossible without anyone's fault. To protect the innocent citizen from cruelty, law applies to the impossibility of performance, officially known as doctrine of frustration, declaring the broken agreement void. See, initially it become void, or later also if the government says that selling coconut is against law, means that is this doctrine will come, doctrine of profession. Then if you have a contract, if you're unable to sell, means you will be protected. Other person can't file any case against you. Initial only it will become invalid, scientifically impossible. ಹೇಳ್ತೀರಾ ನೋಡಿ ಇವರು ಸತ್ತೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ, this person is dead, you if you make it alive, IQCourt law will give 500 crores. Whether it is possible, whether it's not possible, it is not possible. Such contracts are invalid. Subsequent, those all these things you have to write. Everything we explained in our case in the IQCourt study materials, you have to, that's it, nothing is there. Then we'll go to breach of contract. See, contract, you are just cancelling the contract, you are not following the rules as per the contract. That's it, nothing is, no need to explain this. You have to write it on your own. Then fourth unit, we'll go to 4 unit, okay. Then 12 times remedies. What are the remedies? See, ನೀವು ಏನೋ ಬೇರೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬಿಡ್ತೀರಾ, ಇವಾಗ ಮಾಡಲ್ಲ ಅಂತ, ಅವಾಗ ಹೆಂಗೆ, ಏನೇನ್ ಪರಿಹಾರ ಇದೆ ಅಂತ ಎಕ್ಸ್ಪ್ಲೈನ್ ದ ವೇರಿಯಸ್ ರೆಮಿಡೀಸ್ ಫಾರ್ ಬ್ರೀಚ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್. ಕರಾರಿನ ಉಲ್ಲಂಘನೆಗೆ ಇರೋ ವಿವಿಧ ಪರಿಹಾರಗಳೇನು ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ. ವಾಟ್ ಆರ್ ದ ರೆಮಿಡೀಸ್ ಅವೈಲೇಬಲ್ ಫಾರ್ ದ ಬ್ರೀಚ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್? ವೆರಿ ವೆರಿ ಟಾಪ್ ಕ್ವಶನ್, 99% ಇಂಪಾರ್ಟೆಂಟ್ ಕ್ವಶನ್. ಓಕೆ, ಡ್ಯಾಮೇಜಸ್ ರೆಮಿಡೀಸ್ you have to write. Very, you will ask questions like this. ಪರಿಹಾರದನ ಆ ತರ ಎಲ್ಲ ಕೇಳ್ತು. So you have to write. See, you will ask question like this only. See, twisted. We have covered it in our study material. Object of law of contract is remedy the loss of injured person party, not to penalize the party committing the breach. Explain with the reference. Liquidated damages and penalty. ಕರಾರು ಕಾನೂನಿನ ಉದ್ದೇಶವು ವಂಚಿತ ಪಕ್ಷಗಾರ ಹಾನಿಯನ್ನು ಸರಿಪಡಿಸದೆ ಹೊರತು ಕರಾರಿನ ಉಲ್ಲಂಘನೆ ಮಾಡಿದ ಪಾರ್ಟಿಯನ್ನು ದಂಡಿಸುವುದಿಲ್ಲ ಎನ್ನುತ್ತದೆ. ಪೂರ್ವ ಈಗ ನೀವೇನೋ ಗುದ್ಬಿಟ್ಟಿದ್ರ ಇವನ್ಗೆ ಮಿಸ್ ಆಗಿ, ಇಲ್ಲ ಸಾರಿ ಅದು ಬೇರೆ ತರ, you write on some contract, so I will send your car to your home, like you signed on contract. While sending the car, some damage happened in the middle, so you have to see, law will tell you to pay the amount of that damage amount. They will not going to put you in jail. Okay, contract is a civil, breach of contract is a civil, it comes into civil, not a criminal law. It doesn't come under crime. It's a civil case. They will tell you to pay some amount and they will give some money. That's what you have to explain. So this one very, very important. 300% important question. Quasi contract, very, very important. Very 200%. This question also very important. It came less number of time, but he is repeatedly asking this question. 26 it asked. Maybe this time he may skip this question. Oh, chances are there. Okay, you can take it as 50%. But this question is very, very important. 200% important. Only for this sem maybe 50%, because last time only he gave this question. No? We'll see tomorrow. See, only these questions are very, very important. Okay, how many questions? Only 2 questions are important. 2 questions. They may ask differently. This is very, very important. 200%. This question is very important. Don't skip this. Only 2 questions, right? Don't take it as 50. You take it 100, 200%. This question is very, very important. Okay, then we'll go to 4th unit, breach of. Okay, this bottom. As per IQCourt study material, we'll go to this. Damages are compensatory, not penal. This question we already explained. Okay, then what is this question? What are the various remedies? This remedies means you have to pay some money. That's it, nothing. If you breach of contract means you will have to pay some amount. But you have to explain damages. If you have damages, see, damages means compensation, not that damage. Damage means GE means it means you have damaged something, you have spoiled something. Damages, if you add S means it's become compensation. Okay, like that. This is very important. Without these things, simply if you're writing, very difficult. Then this is important. I've explained. Then third question, quasi contract, very, very important. I will explain. This quasi contract means it is a contract without making the contract. It's a contract without making the contract. That's very simple. Very, very easy. ಮೀನ್ಸ್ ನೀವೆಲ್ಲೋ ಹೋಗ್ತಾ ಇರ್ತೀರಾ, ಹೋಗ್ಬೇಕಾದ್ರೆ ಮಿಸ್ ಆಗಿ ಏನೋ ಸಿಕ್ಬಿಡ್ತು, ಅದನ್ನ ತಗೊಂಡೋಗಿ ಕೊಡ್ತೀರಾ. ಅವ್ನು ಬಂದ್ಮೇಲೆ ಆಟೋಮೆಟಿಕ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಗಿದೆ, ನೀವು ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಅವ್ನು ಖರ್ಚು ಮಾಡಿದೆಲ್ಲ ಕೊಡಬೇಕು ಅಂತ. ಅನದರ್ ಎಕ್ಸಾಂಪಲ್, ನೀವು ನಿಮ್ಮ ಮನೆ ಮುಂದ್ಗಡೆ ಅಮೆಜಾನ್ ಅನ್ನ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾನೆ ಐಟಮ್, ಸೊ ಅದು ನೀವು ತಗೊಂಡು ಯೂಸ್ ಮಾಡ್ಬಿಡ್ತೀರಾ, ಅಲ್ಲ ಅದನ್ನ ಐಟಮ್ಸ್ ತಿಂತೀರಾ, ಸೊ ನೀವು ಅಮೌಂಟ್ ಕಟ್ಟಬೇಕಾಗುತ್ತೆ. ನೀವೇನು ಅಗ್ರಿಮೆಂಟ್ ಇಲ್ಲ, ಕಾಂಟ್ರಾಕ್ಟ್ ನೀವೇನು ಪರ್ಚೇಸ್ ಮಾಡಿಲ್ಲ, ನೀವೇನಾರ ಯೂಸ್ ಮಾಡಿದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ ವಿಲ್ ಹ್ಯಾವ್ ಟು pay that. Section 20, very, very important. 300% important. You will have to study this in 2nd sem, 3rd sem, 4th sem. Everywhere you will study this. Section 70, very, very important. If you don't, you are not able to understand, you just write this. Section 68 to 72, you just start writing this one. This is just obligations, arises by law, not by ಎನಿ ಆಫರ್. ನೀವೇನು ಕಾಂಟ್ರಾಕ್ಟ್ ಮಾಡಿ ಏನಿಲ್ಲ, ಆಟೋಮೆಟಿಕ್ ಬಂದ್ಬಿಡುತ್ತೆ. ಯಾಕಂದ್ರೆ ನೀವು ಬೇರೆ ಅವ್ರೇನೋ ಮಿಸ್ ಮಾಡ್ಬಿಟ್ಟು ನೀವು ತಿಂದ್ಬಿಟ್ಟಿದ್ರೆ, ಸೊ ನೀವು ಕೊಡಬೇಕಾಗುತ್ತೆ ಅವ್ರಿಗೆ ಅಮೌಂಟ್ನ ಅಷ್ಟೇ. ಅದೇ ಕೊಸಿ ಕಾಂಟ್ರಾಕ್ಟ್, ನ್ಯಾಯ ನೀತಿ ಧರ್ಮ. ಈ ತರ ಅನ್ಕೋಬಿಡಿ, ಕೊಸಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಮೇಲೆ ನ್ಯಾಯ ನೀತಿ ಧರ್ಮ ಅನ್ನೋದು ಇರ್ಬೇಕಲ್ಲಪ್ಪ ಅಂತಾರಲ್ಲ, ಅನ್ಯಾಯದ ಲಾಭ ಪಡ್ಕೊಳಕ್ಕಾಗಲ್ಲ, ಅದನ್ನ ಅಷ್ಟೇ ನ್ಯಾಯ ನೀತಿ ಧರ್ಮದ ಪ್ರಕಾರ ನೀವು ಕೊಡಬೇಕು ಅಂತ ಅಷ್ಟೇ. Asta. That is the question. Then we'll go to last unit. What is specific? Definite 200, 300 to 400%. This is so very, very important question. Specific relief. Okay, specific. Contract he has cancelled. He is not ready to give his house, but he has signed the contract. I can ask, sir, I want that house only, that model only, that piece only, that car only. I want that only, sir. That is a very, you can ask. That is specific relief. You can ask for the damages, nashta pariyara. Pariyara, you're asking for the compensation or something different way. Monetary, cash can't always fix the unique losses. ನೀವೇನೇ ಹೇಳ್ತೀರಾ ಆ ಮಾಡಲ್ ಬೇಕು ನನಗೆ ಅಂತ, ಆ ಮಾಡಲ್ ಇಲ್ಲ ಸರ್ ನಾನು ದುಡ್ಡು ಕೊಟ್ಬಿಡ್ತೀನಿ ಅಂದ್ರೆ ಇಲ್ಲ ನಂಗೆ ಬೇಕು ಅಂತ ನೀವು ಕೇಳ್ಬೋದು. ಅದೇ ಸ್ಪೆಸಿಫಿಕ್ ರಿಲೀಫ್. ಯು ಕ್ಯಾನ್ ಆಸ್ಕ್ ಟಾರ್ಗೆಟೆಡ್ ಕೋರ್ಟ್. Targeted course help restoring the exact lost property, forcing specific action to protect everyday civil rights without punishing the criminal offences. Forcing A to hand over the rare unique painting to buyer B instead of just giving back the. So you like the paint, you are asking after contract, he is telling, oh, okay, I will not give. Then you can go and ask the court, sir, he is not giving. Give me, sir. Tell him to give me, sir. That is what specific relief. Okay. Then now 50 unit, which are the important questions? I will tell. This is very, very important. That is what specific contract. So the specific performance of the contract. Okay. Very, very important. You will ask directly under which contract. We can't ask. Okay. Under which this is, you will ask like this only. You will not ask direct question. Under what circumstances contract can't be specifically enforced? Injection 200% important. That is 400%. This is 200% important question. Definitely ಇಲ್ಲ ತಡೆ ಆದ್ನೆ ಕಾಮನ್ ಸೆನ್ಸ್ ಇದ್ರೆ ಬರೆದು ಬಿಡ್ಬೋದು. ನಿಮ್ಮ ಮನೆ ಯಾರೋ ಏನೋ ಮಾಡೋದಕ್ಕೆ ಹೋಗ್ತಿದ್ದಾರೆ, ಅವಾಗ ಅವ್ರನ್ನ ಸ್ಟಾಪ್ ಮಾಡಿಸಿದಲ್ವಾ, ಅದೇ ತರ ಇದು ತಡೆ ಇದನ್ನೇ ಕೊಡೋದು. ಯಾವ ಸಂದರ್ಭ ನ್ಯಾಯಾಲಯ ಸ್ಟಾಪ್ ಮಾಡಬಹುದು ಅಂತ ಅಷ್ಟೇ. ಡ್ಯಾಮೇಜಸ್ ಸ್ಪೆಸಿಫಿಕ್ ರಿಲೀಫ್. ಸಿ ದಿಸ್ ಸಾಮಾನ್ಯ ಬಂದು ದಿಸ್ ಕ್ವಶನ್ ನಾಟ್ ಇಂಪಾರ್ಟೆಂಟ್, ಬಟ್ ಇಫ್ ಕ್ವಶನ್ ಪೇಪರ್ the examiner wants to make the exam really tough, definitely this question they will ask. Okay, same thing, you have to write 2-3 line extra. I will show you in the study material. Okay, I will go to, this is the high quality, this is the premium high quality study materials you will not get anywhere else. This is the way we explained all the points, very simplified manner, very easy manner, with full of research, with full of hard work, with scientific way we explain this. This one is what is this one? Injection tadiyazne ade nilsbidodu ashte. Instead of waiting for the illegal damage to happen, paying the cash damages, civilized law stops them before it starts. ನೀವೇನೋ ಮಾಡಿದ್ರೆ ಹೊಡೆದಾಕಕ್ಕೆ ಹೋಗ್ತಿದ್ರ, ಹೊಡೆದಾಕದ್ಮೇಲೆ ಇಸ್ಕೊಳ್ಳೋಕ್ಕಿಂತ ನಾನು ಹೊಡೆದಾಕಿಂತ ಮುಂಚೆಲ್ಲ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬಿಟ್ಟು ತಡೆಯದೆ ತಿನ್ಬಿಡೋದು, ಅವ್ನು ಹೊಡೆದಾಕಬಾರ್ದು ಅಂತ ಅಷ್ಟೇ. ತಗೊಂಡು ಹೋಗ್ತಿದ್ದಾನೆ ಏನೋ ಐಟಮ್ ತಗೊಂಡು ಹೋಗ್ಬಾರ್ದು ಅಂತ ಮೊದಲು ಸ್ಟಾಪ್ ಮಾಡಿಸ್ಬಿಡೋದು, ಅದೇ ತಡೆ. ದಟ್ ಈಸ್ ದ ಇಂಜೆಕ್ಷನ್. ಅಷ್ಟೇ, ವೆರಿ ಸಿಂಪಲ್. ಕಾಮನ್ ಸೆನ್ಸ್. You have to temporary injection, permanent injection, and mandatory injection. Means you have to bound to do it immediately. Like that's it. Very simple, very easy question. The entire subject is very easy. Okay, all of you should clear this exam. All of you should pass this exam, become topper. Explain the provisions related to the recovery of movable, immovable property under a specific relief. So this question also them asked. So I have given to all the question to all our students, so they should not fail or score less. All our IQCourt law academy students should become toppers. Become toppers, become university toppers, become college toppers. Okay, that is the way we have put all our hard work. We studied 500 questions per subject. We have put so much of effort to help our students. Okay, all of you should clear the exam. Okay, only these questions will come in the exam tomorrow. You should come and tell me, sir, you got the same question. Then you should come and tell me. I will tell you, yeah, I know it. I will tell you like that. Okay, you should tell me. You will tell me. I know. You will come and tell me. You will get the same question. Whatever I discussed right now, you will get the same questions in the exam. Whatever I explained in the study material, you will get the same question. That is the guarantee. That is the promise we are making to our students. That is the hard work. That is the effort we IQCourt Law Academy has put to help KSLU students to succeed in their case law career. We have made a long notes, short notes, everything we have made the last points also, everything. Enjoy. It is a festival of KSLU exams. Enjoy this festival. You will get it only 6 months in once. So you should enjoy these exams. All the best. All the best. All the best. Score well. If you have any doubt, you can contact me. It's very easy exam. Enjoy this exam. Basic common sense you should use to clear this exam. Some of the sections you write, some case laws, 5 case laws at least. You will study 5 case laws. 5 unit, 5 case laws. Study some of the important case laws. Even if you study 4 unit, 3 units also, you can clear the exam. You don't require to study all of them if you don't have time. Very important question you study. Okay, all the best. Go and write the exam tomorrow. You will get the same question. That is the nobody will tell you. Before the exam, nobody will tell you these questions only will come. We are telling you will get the same questions from our study materials. Okay, all the best. Bye bye. Ending. I don't have time. Still, I need to show, right? I need to show it to students so that you should be able, you should understand what I'm telling. You should believe, right? So not only theory, all problems will come from the IQCourt study materials only. So I need before exam I should publish it, right? So that tomorrow after you come back, you should you need a proof. Tomorrow if I am showing see all these questions, then you will not believe, right? That is the reason I'm going to display the question problems of contract 1 of first semester KSLU 3 program. Let us go through it. Tomorrow you will get 3 out of 3 problems from our study materials only. Otherwise, at least 2 you will get. 99% you will get 3 out of 3 question problems from the IQCourt study materials. You may miss one question, but 1%, remaining 1%, you may get one question less. 2 out of 3 questions from our IQCourt study materials. That is a guarantee we are giving to our students. Let us start. I will start displaying the question. I'm not going to explain. I don't have time to do it. Question regarding the customer picking an item with a price tag in a self-service shop and the cashier refuses to sell. It is correct. He can refuse. See, it is just an invitation to offer. Customer makes the proposal when they're bringing them the item. So he no need to give, no obligation to give. Okay, next question. Regarding the seller who voluntarily sells a high valuable asset for a low price, later rises the question. No, it is not valid. Selling is valid. Consideration not important. Okay, next question is regarding the timeline for raising letters where the person posts an acceptance but later sends a revocation. Court must decide which message arrives first to validate. The acceptor can revoke their acceptance, but cancellation message should reach the offerer before or at the exact same time as what is null. So I will I'm doing a time. I will explain. It's a question regarding the missing person or dog where the reward is announced. So whether he is eligible or not. That's regarding that question. Then acceptance regarding the buyer who accept as an offer to purchase a car but attach a new condition. Though this question also important in regarding the broken social promise between friends and wife and husband, like that. Okay, and this question and regarding the contract killer who files the contract killer who files a civil suit to recover his contract killing money. So this is you can't file which is against the law. Okay. Question regarding the minor selling the scooter for a specific amount. Regarding to minor, you'll get the question. Okay, same question you get. Minor who lies about the age related to the. Even if it lies also, you don't have power to get it. Okay. Question regarding the person who sells the high valuable item for a low price. So he acceptable. Okay. But regarding the extreme blackmail, doctor threatening to publish a private record, husband threatening suicide, criminal kidnapping, force, these things. Threatening to defame someone, commit a suicide. This question also you will get voidable. These are all voidable. See, if you have found threatening and then your signing means no, that contract will be invalid. However, that's it. Section regarding the religious peril conversion. This also, see, these all questions are there. Regarding the customer who play car music player, she's stolen from the paid parking. This question you get. This also you will get tomorrow. Any of these questions will come in the exam. Regarding the middleman, specific performance, regarding 3 major telecom operators. This year we have prepared for our students. This also they promise to pay money. Certain promise to pay money. These are the questions will arise. One of these questions will come. We have detailed answers also. We have provided to our students. See, these are all the questions we have combined. These are the different ways you may ask the question, but you have to give the same answer. See that like this we have prepared the study materials sections. We have explaining you the explanation, exam, judgment, suggestion, justification, case laws, everything. We have explained for the each of the question problems. See, 50 pages are there. We explained everything. Everything. You will get the question exactly from this study materials. We have provided all our student. Tomorrow you will get the question from this only. All 3 out of 3 problems. Okay, we'll come back and see tomorrow. Okay, all the best. Bye-bye.